Thank you. I'm Judge Robert Jones. I've been a judge for 51 years, 52 years there, and started on the state court, the Supreme Court, and I've been on this court for the last 25 years.
Good afternoon. My name is Steve Powers. I'm an attorney in private practice at the law firm of Parsons, Cornell, and Grimes.
Welcome, everyone. So we are going to start today with a question, and I'd like you to have our panel members. Please go ahead and introduce yourself.
Good afternoon, I'm Stella. I'm the captain of Unit 3, which discusses how the Constitution has been changed to further the ideals contained in the Declaration of Independence.
Hi, my name is Jay.
Hello, I'm Maddie.
Hi, I'm Julia.
Good afternoon, my name is Jonah.
Hello, I'm Olivia. We'd like to thank our coaches, Misha Isaac and Christy Splitt, our teacher, George Tenike, and our principal, Peyton Chapman. We'd also like to thank you for being here today.
Thank you. It's our pleasure. So, our question today, I will go ahead and read it, and then we will begin with your presentation. Our question today is as follows. The 14th Amendment mandates that no state shall deprive any person of life, liberty, or property without due process of law. It does not define due process of law, however. How would you explain the concept of due process of law, keeping in mind a couple points? What is the relationship, if any, of due process to natural rights philosophy and the principle of limited government? And secondly, how would you distinguish between procedural and substantive due process, and why are both important?
Due process, infused with meaning by Supreme Court cases, has evolved over time.
Gideon v. Wainwright, which guarantees the right to counsel, illustrates criminal procedural due process.
Goldberg v. Kelly, which guarantees notice and a hearing before government benefits can be taken away, illustrates civil procedural due process.
Griswold v. Connecticut, which guarantees the right to privacy, illustrates substantive due process.
Due process of law requires that the government must comport with principles of fairness when burdening constitutional rights. And its most basic due process can be described as fundamental fairness, and it prohibits the government from acting arbitrarily and unfairly. The procedural guidelines encompassed by due process allow people to be free from a repressive government and prevent that government from infringing upon people's rights. Due process is derived from Magna Carta, English common law, naturalized philosophy, and other influences. Due process is related to natural rights philosophy, which provides that everyone has inalienable rights that cannot be taken away. Specifically, life, liberty, and estate are believed to be rights one has just by virtue of being human. Natural rights philosophers imagined a time before government. In this state of nature, everyone has the rights to life and liberty because there is no controlling authority. Everyone also has the right to estate because ownership derives from cultivation of property.
People are entitled to each of these rights as long as they don't conflict with rights of others. Natural rights philosophy is the idea that a government is established to protect and preserve these rights. The relationship of due process to natural rights philosophy is that due process prevents the government from infringing upon natural rights by barring it from acting arbitrarily.
The principle of limited government is also related to due process. Limited government means that the power of the state to interfere in the people's rights is restricted by a constitution. In a limited government, the government has specific powers, not a general grant of power. This idea is linked to due process. Due process limits both laws and how laws are executed, so that the government is restricted to depriving rights under fair circumstances and using fair procedures. Due process ensures the government is limited with burdening rights by making clear how the government may and may not act in certain situations.
The Supreme Court has applied due process in two ways, procedural and substantive. Procedural due process is the principle that if the government is denying their citizens the rights to life, liberty, or property, it must follow fair and established procedures. This is important because it prohibits the government from acting arbitrarily or unfairly. Procedural due process requires that the government give adequate notice and an opportunity to be heard before denying any rights.
Substantive due process provides that the government cannot deprive a person of life, liberty, or property without sufficient justification. As Chief Justice Roberts put it in his dissenting opinion in Obergefell v. Hodges, The theory is that some liberties are so rooted in the traditions and conscience of our people as to be ranked as fundamental, and therefore cannot be deprived without compelling justification.
Procedural and substantive due process can be explained using this example. Josie is a student at a public high school. After she was caught taking birth control pills at school, her principal expels her without a notice or a hearing. She then brings a due process claim against the school. Her procedural due process argument is that she has the right to a notice of the charge against her and an opportunity to explain and appeal, as established in Goss v. Lopez. Her substantive due process argument is that she has the right to use contraceptives, as established in Eisenstadt v. Baird.
As stated in Magna Carta, a free man's right shall not be abridged, except by the lawful judgment of his equals, or by the law of the land. It is this principle that, still today, is one of the pillars of American government.
Thank you. We're now ready for your questions.
All right, thank you very much for your presentation. We'll begin with our first question from Judge Jones.
Well, the Supreme Court has talked about fundamental rights. Can you please name some examples of fundamental rights that they have accepted and identified, and those that they have rejected?
One fundamental right that the Supreme Court has accepted is the fundamental right to marry, as established in Obergefell v. Hodges, Loving v. Virginia, and Zablocki v. Redhale. This trade starts back in Loving v. Virginia, in which the court held that the right to marry is fundamental and that interracial couples can marry. This then moved on to Zablocki v. Redhale, in which a father who wasn't paying child support was not able to marry due to a state law. But however, this was overturned by the Supreme Court because yet again, the right to marry was fundamental. And then, most recently, last year, in Obergefell v. Hodges, the court held the right to marry is fundamental and that same-sex couples should not have this right abridged.
One right that the Supreme Court has rejected to be fundamental is the right to die, or the right to physician-assisted suicide. In the 1997 case Washington v. Glucksberg, the court ruled that because the right to die was not deeply rooted in our society, it should not be fundamental and should not be protective under substantive due process. However, if we look internationally, this past year, the court in Canada, in Carter v. Canada, just ruled that the right to die was fundamental.
If I may add just one more fundamental right, the fundamental right to privacy was established in the case Griswold v. Connecticut, and Justice Douglas expanded on his idea of a penumbra of emanations that was in the Bill of Rights, and where the right to privacy isn't directly stated in the Constitution. However, it's evident throughout the First, Third, Fourth, Fifth, and Ninth Amendments, excuse me.
Another right that has been decided that was not fundamental is the right to a civil jury trial, and it was decided in the case Minnesota Railroad Company versus Bombolis that this was not fundamental enough to incorporate to the states.
In the 1925 case, Meyer v. Nebraska, the Supreme Court held that the right to parent is a fundamental right.
Thank you. So why does controversy still continue over why certain rights should be regarded as fundamental or not?
A lot of controversy continues over whether the Constitution should be interpreted with the original intent of the framers or with our so-called evolving standards of decency. This was a big issue in the case of Obergefell v. Hodges because many people believe that while the fundamental right to marry did exist, the fundamental right for same-sex couples to marry did not exist because it had been outlawed for over 200 years.
In the case Moore v. East Cleveland, the court came up with the test to decide whether a right would be fundamental or not, which is whether it is deeply rooted in our society. And some people would argue that this line, the controversy surrounding this test is because the line, whether it is deeply ingrained or not, is getting fuzzy.
Another issue with declaring rights fundamental and under this doctrine established in Moore v. East Cleveland is that some rights that are fundamental to us as human beings are inherently bad. If you look at the case of Dred Scott v. Sanford, Justice Taney claimed that the right to slavery was fundamental to us as human beings, which it was at the time of the case. However, this is inherently wrong. So now you can see that in society today, it can create controversy because sometimes the things that are fundamental to us as humans are not exactly right.
Justices Roberts and Scalia feel that declaring rights fundamental is actually creating the law and not interpreting the Constitution. As Justice Roberts stated in his speech to Cornell University, if you look at the Lochner case, they're not interpreting the Constitution, they're making the law. This was evident in the case Lochner versus New York, where they found a right to contract for bakers to work over 60 hours a week just in the word liberty of the Due Process Clause of the 14th Amendment, which is not strictly tied to the original intent of the Constitution.
Okay, so my understanding then, if Congress wants to regulate a fundamental right, that we have to establish a compelling justification or a compelling state interest to do so. So could you talk to me a little bit about what a compelling state interest is and why Congress needs to establish that?
I think one compelling state interest that would drive Congress to, or the Supreme Court to interpret the right to die as fundamental is that it is very important to many of the people who are going through it through state laws. In Oregon, we did pass an initiative for the Death with Dignity Act, and it has been used. Many people are moving from other states to coming to Oregon just so that they can utilize the right to die. And it is also a compelling state interest because people in states where it's illegal, the doctors that administer the drugs to the people who wish to commit suicide, they are prosecuted and often put in jail for this.
Another example is the fundamental right to privacy, which the court recognized, yet the Congress passed the 2001 Patriot Act, which infringed upon people's privacy acts and has led to the NSA surveillancing people's phones.
Okay, so, well, more specifically, why do we as Congress need to show a compelling government interest in order to regulate a fundamental right?
I think the compelling interest is absolutely key to regulate a fundamental right, because the whole concept of declaring fundamental rights is to create an unalienable right for us as the people that needs to be protected no matter what. And this compelling interest basically says that sometimes you have to find a way to regulate this fundamental right, because we have issues such as terrorism, and the Patriot Act obviously infringes upon our privacy. However, we need to stop terrorism because it can hurt more people. So the compelling interest comes into play because the government needs a sufficient reason to prove that they need to regulate someone's fundamental rights.
Thank you very much for our time.
Congratulations.
Yes. Come again, your comments?
Sure. So I would say your opening and throughout your follow-ups, you had wonderful and very solid examples. I was impressed by the alliteration of what you had between Gideon, Griswold, and a couple of the others. But then you actually pulled them out and used them in your follow-up questions, which I thought showed great constitutional application. The other thing I would say is that the example, you took on big issues like marriage and Patriot Act and terrorism, right? But then you had the school example in your opening. And so to use those examples, big and small, I thought demonstrated a great understanding. I'm very impressed with you. Congratulations.
Yes. I thought that you did a wonderful job in bringing in both old sources and new sources. I love that you were right on Obergefell and that you were ready to talk about that, but you also talked about the Magna Carta too. And you managed to bring those different kinds of sources together in a way that made sense to understand that there's a historical component as well as a very modern one to what is going on in this area. I thought that you were very responsive to the questions and that your reasoning in each of the points that you made was well tied to both doctrine and history.
I liked the presentations. I adopt what my colleagues have said already. I would give you 4 stars.
So thank you very much. You did a wonderful job.